As a beginning nurse, I'm sure that when you have chosen this profession, your thoughts were focused more on seeing yourself serving people in the future, right? So I'm sure it never occurred to your mind yet uh, these words, these terms, like malpractice, incompetence, negligence, deceit, fraud. So these words probably never entered your mind. However, uh, it has been reported, no, that nurses are increasingly finding that legal issues are an everyday part of nursing practice. And studies show that more nurses are being sued for on-the-job behaviors and actions, no, than ever before. So recent issues like nursing shortages and hospital cost-cutting initiatives have even placed extra burdens on nurses, increasing their workloads and also increasing the margin of error. Because imagine you will be caring for more people, no, than you practically can, especially here in the Philippines. So with this increased margin of error, nurses can be found legally liable or responsible for mistakes made due to a variety of reasons, for many reasons. So perhaps they did not do something they were supposed to do, or they did something they should not have done. So it's important, as a beginning nurse, that you understand these legal liabilities in nursing and hope that you can, you can prevent yourselves from experiencing this. So let's have first malpractice. Malpractice occurs when a nurse fails to competently perform his or her medical duties. And this uh, this failure can bring harm to the patient. And there are a variety of ways that a nurse can harm a patient, from administering the wrong medication to failing to notify a doctor about certain observations. Yeah. So it is the idea of improper or unskillful care of a patient by a nurse. Or also it is a failure to meet the standard of care, which resulted to harm experienced by the patients. Okay, so that is malpractice. Next is incompetence. Um, Incompetence refers to that lack of ability or lack of legal qualifications or lack of fitness to discharge the required duty. So it means the display of lack of knowledge, skill, or judgment in the respondent's care of a client or delivery of nursing services that having regard to all the circumstances rendered the respondent or the nurse unsafe to practice at the time of such care of the client or delivery of nursing services, or that renders the nurse unsafe to continue in practice without remedial assistance. The next is the negligence. Negligence is synonymous to carelessness. It's a failure to act as an ordinary prudent person or action contrary to what a reasonable person would have done. So it can be defined as a failure to take reasonable care or steps to prevent loss or injury to another person. So nursing negligence is when a nurse who is fully capable of caring does not care in the way a reasonably prudent nurse would do. And as a result, the patient suffers unnecessarily. Okay? So that's negligence. Now, how about deceit? It is an act, or any act, declaration, or practice which misleads a person or which causes him to believe what is false. Okay? while fraud is a wrongdoing or misconduct or an act resulting from a willful act to deceive, or fraud is also a deceitful practice, no, where rules of common honesty is required. Yan. Okay, so these are certain legal liabilities, no, in nursing. There's also another one, I think, false statement, which is an allegation or statement that is deceitful with intention to commit a fraud. No, so more specifically, okay. On professional negligence, there are certain elements that needs to be present for it to be considered professional negligence. And we have this, uh, ano, three elements: on duty, failure to meet the standards of due care, and foreseeability of harm. So, for an act to be, or a nurse to be considered professional negligent, there should have been existence of duty, no, on the part of the nurse, uh, who is charged to use due care under certain circumstances. However, despite that existence of duty, the nurse fails to meet the standards of due care, and also the foreseeability of harm resulting from failure to meet the standards has occurred. So the fact that the breach of this standard resulted in an injury, no, is a reason, no, for it to be called professional negligence. Now, there are 5 legal doctrines to describe professional negligence, one of which is the captain of the ship doctrine, which is a legal doctrine that holds uh, that during an operation, like for example in a surgical ward, no, during a surgical procedure, a surgeon of record is liable for all actions conducted in the course of the operation. So the surgeon is the captain of the ship, and who is liable for all actions that's going to happen, no, in that during the course of that surgery or operation. So all the actions of his members, it is the captain of the ship who will be liable, and in this case, the surgeon. So, no, even though the nurses, no, the circulating nurse, the scrub nurse, uh, and the anesthetist, no, even though they're employed by the hospital, but because of the doctrine, or this doctrine, the captain of the ship doctrine, no, it bounds the surgeon, no, liable for all the actions of the members during the surgical procedure. Okay. Another doctrine that describes professional that helps establish professional negligence is the doctrine of respondeat superior. So this basically asserts that to let the master answer for the acts of the subordinate. So an employer will be liable for an employee's negligent actions or omissions that has occurred, no, during the course and scope of the employee's employment. Okay, so this is the doctrine of the respondeat superior. The next is the doctrine of corporate liability. No? And uh, the liability, this basically pertains to the liability of the corporation, no? Like the hospital, in cases of defective equipment or facilities which can cause harm or injury to the patient. Okay, so it determines the extent to which a corporation as a legal person can be liable, no, for the acts and omissions of the natural persons it employs. Now, another doctrine is the doctrine of force majeure, which means force majeure pertains to the irresistible force, one that is unforeseen or inevitable. So, with this doctrine, it is asserted that no person shall be responsible for those events which cannot be foreseen and which are inevitable, such as floods, fire, earthquakes, and accidents. However, habitual tardiness due to heavy traffic is not considered an excuse, no, for force majeure. Next is the res ipsa loquitur, which wherein three conditions are required to establish a defendant's negligence without providing specific conduct. So it is presumed that the person is negligent if he or she had exclusive control of whatever caused the injury, even though there is no specific evidence of an act of negligence, and without negligence, the accident would not have happened. Okay? So how about torts? What are torts? Torts in common law jurisdiction is a legal wrong, no, a civil wrong committed against a person or property, independent of a contract, which renders the person who commits it liable for damages in a civil action. So it is an act or omission, no, that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. It can include intentional infliction of emotional distress, uh, negligence, financial losses, injuries, invasion of privacy, and many other things. Now, there are examples of torts, and these are battery, assault, defamation, false imprisonment or illegal detention, invasion of right to privacy, and breach of confidentiality. For battery, battery is unintentional, unconsented touching of another person. So it is unintentional and wrongful physical contact with another person without that person's consent. That includes some injury or offensive touching. Okay, so that's battery. How about assault? Assault is the imminent threat of harmful or offensive bodily contact. It includes physical or verbal intimidation. A gesture that the client may perceive as a threat is an assault if the client believes that force or injury may follow. So telling the client that you are going to restrain him in bed if he tries to get out of bed without assistance can be considered already as an assault. Right? How about defamation? Defamation is a false and unprivileged statement of fact that is harmful to someone's reputation and published with fault, meaning as a result of negligence or malice. Okay, so there's malice. Um, Now there are two types of defamation. One is slander, and the other one is libel. Slander is an oral defamation of a person by speaking unprivileged or false words by which his reputation is damaged. While libel is defamation by written words, no? Cartoons or such representations that cause a person to be avoided, ridiculed, or held in contempt, no, or tend to injure him in his work, right? Next is the false imprisonment or illegal detention, which is the unjustifiable detention of a person without a legal warrant within boundaries fixed by the defendant by an act or violation of duty intended to result in such confinement or detention. Next is the invasion of right to privacy, which is the right to be left alone. to be free from unwarranted publicity and exposure, to public view. Okay? So this invasion of right to privacy is a tort based in common law, allowing an aggrieved party to bring a lawsuit against an individual who unlawfully intrudes into his or her private affairs, discloses his or her private information, publicizes him or her in a false light, or appropriates his or her name, for personal gain. Okay? Yun. The next is the breach of confidentiality, which is the right not to divulge information from a patient's chart to improper sources or unauthorized persons. It occurs when data or information provided in confidence to you by a client is disclosed to a third party without your consent. Okay, so that's breach of confidentiality. Aside from torts, we're also going to discuss crimes and misdemeanors and felonies. Crimes are actions committed or omitted in violation of the law. So they constitute an offense because of this commission or omission. So there is an offense that may be prosecuted by the state, and is punishable by law. Now, there are elements, that needs to be present for an action to be considered a criminal offense. The first is the criminal action itself, and the second one is the evil or the criminal intent. Now, criminal action deals with actions or offenses against public welfare. That's why in response, the government has instituted also actions to punish offenses against the public. So, and while criminal intent or evil intent is the state of mind of a person at the time the criminal act is committed, that is, he or she knows that an act is not lawful, and even though he or she already recognized that the action is unlawful, but still he decided to do it anyway. So there was deliberate intent, it was voluntary, it was conscious, there was knowledge. All right. Now there are types of criminal action, and these are misdemeanor and felonies. So what are misdemeanors? Misdemeanor is a general name for a criminal offense which does not in law amount to felony. So punishment is usually a fine or imprisonment for a term of less than 1 year. But for felony, it's a public offense for which a convicted person is liable to be sentenced to death or to be imprisoned in a penitentiary or prison. Also, felony is an action committed with deceit and fault. All right? Felonies are further classified according to the degree of the acts of execution and according to the degree of punishment. According to the degree of the acts of execution, the felonies are categorized or classified as consummated, frustrated, and attempt. So what is the difference between these three? A consummated felony is when all the elements necessary for its execution and accomplishment are present. So there is criminal intent, and there is execution of the criminal act. While in frustrated felony, when the offender performs all the acts or execution, which will produce the felony as a consequence, but which nevertheless do not produce it by reason. So there's criminal intent, there's criminal act, but the consequence did not happen. So why? For whatever reason, by reason of causes independent of the will of the perpetrator. Okay. Now, for attempt, It is when the offender commences the commission of the same directly overt act, so there is an intent, but does not perform all the acts or execution which shall produce the felony by reason of some cause or accident other than his own spontaneous desistance. So, if you remember when we were trying to analyze the elements of human acts, well, as you try to examine the intent, the act itself, and also the consequence. So, in consummated, all the three elements are present. While in frustrated, there is criminal intent, there is criminal action, but no consequence. While in or no criminal consequence. While in attempt, there is a criminal intent, but unable to do the criminal act, and so there is also no criminal consequence. All right. Now, according to the degree of punishment, felonies are classified as grave, less grave, and light. Grave felonies are those to which the law attaches the capital punishment, which is death, or penalties which in any of their periods are afflictive. Imprisonment ranging from 6 years and 1 day to life imprisonment not exceeding 6,000 pesos. No? Also, for less grave felonies, these are felonies which the law punishes with penalties, which in their maximum period are correctional. No, so um, correctional by nature. So imprisonment range from 1 month and 1 day to 6 years, or a fine not exceeding 6,000 but not less than 200 pesos. Okay? Now, for light felonies, these are infractions of law for the commission of which the penalty of arresto menor or imprisonment for 1 day to 30 days or a fine not exceeding 200 pesos or both of which are imposed. And this is punishable only when they have been consummated, with the exception of those committed against a person or property. Okay? Um, you also have this degree of punishment in the handouts. The degree of punishment for felonies, including the imprisonment, the length of imprisonment, as well as the fine. Okay. Now, we also need to understand conspiracies, during the commission of a crime. Conspiracies exist when two or more persons agree to commit a felony and decide to do it. So, uh, of course it involves a principal, and accomplices. Okay, so for principal, uh, this conspiracy, uh, is categorized into principal by direct participation, um, and also principal by indispensable cooperation, and principal by inducement. Okay, so these three. Tapos later, we'll discuss about how about the accomplice, what happens. So for the principal, by direct participation, this refers to those who actually and directly take part in the execution of the act. So this requires that the principal, by direct participation, must be at the crime scene. Okay? Also, it should be established that there is unity of intention. So the person participated, agreed, or concurred in the criminal design, intent, or purpose of the crime or resolution. Aside from the unity of intention, there has to be unity of action as well. all participated in the execution or carrying out of the common intent, design, or purpose, or objective by actions that are intended to bring about the common objective. So that's unity of action. And next is the participation in both. No, the participation of both intent and action. So this must be present, no, when we categorize the principal by direct participation. Now, in principal by indispensable cooperation, what happens, no, when the principal is by indispensable cooperation? This refers to those who cooperate in the commission of the offense by another act, without which it would not have been accomplished. So there must be a community of design or common purpose between the principal by direct participation and the principal by indispensable cooperation. So there is a community of design or common purpose between these two, but not necessarily a conspiracy. No, so the principal by indispensable cooperation knows or is aware of the intention or purpose of the principal by direct participation, and he cooperates or concurs in its realization by performing an act without which the offense would not have been accomplished if hindi siya tumulong. So, yun. In principal by inducement naman, these are principals who induce, no, to commit a crime either by force or inducement. So, examples of this is by the giving of a prize, promise, or reward. No? So, this must be made with the intention of procuring the commission of the crime and not as an expression of appreciation. So, the same must be the sole reason for the commission of the crime. No? Giving the prize, promise, or reward. Also, by giving words of command. And another by the use of inciting words. So these are words uttered while a crime is going on by one who is present and are directed to a participant in the crime, such as the word, sige pa, kick him, patayin mo, bubugin mo, yan, sul-sul, kumbaga. So these are principal by inducement. Okay, so principals are categorized into these three. Again, principal by direct participation, principal by indispensable cooperation, and principal by inducement. Then, for the accomplices during conspiracy, they are those persons who cooperate in the execution of the offense by previous or simultaneous act. They are also accessory before the fact. So, yun. For accessories naman to the crime, they are those who take part subsequent to its commission by profiting themselves or assisting the offender to profit from the effects of the crime by concealing or destroying the body of the crime. No? So, they are then called accessory after the crime, while accomplices are accessory before. Okay? Yun. Now, there are circumstances affecting criminal liability. In general, these circumstances are either defenses or modifying circumstances. Okay? With defenses, these are those which, if proven, if these defenses were proven, may result to an acquittal of the offender from the crime charged or may lead to non-criminal liability. And that's why they are the reasons that they are advanced by the accused, so that he may not be held criminally liable. Now, defenses are classified also as to form, effect, and source. As to form, defenses are classified into positive and negative. So, anong kaibahan? Pag positive, they are often called defenses in the nature of admission and avoidance. So, the accused admits authorship of the act or omission charged and imputed to him, but he puts up matters to avoid criminal liability, of which will result to his acquittal. And this can be in the form of justifying, exempting, and absolutory causes, no, or circumstances, which are all affirmative, no, affirmative defenses. Negative defenses, on the other hand, are the accused are defenses when the accused denies authorship or having performed the act or omission imputed to him. And examples of these are denial, alibi, mistaken identity. Okay, so these are the defenses according to form. Now, according to effect, defenses can be total or perfect and partial. So, for total or perfect, these are defenses, no, that are those that the effect of which will totally exonerate the accused. For example, a complete justifying circumstance, no, or amnesty. Yan. So that's an example. Amnesty is an example of a total or perfect defense according to effect. Partial, on the other hand, are those which are intended to lessen the liability of the accused. So they include proof, no, the offense is a lesser offense, or that it is of a lower stage of execution, that the accused has a lower participation and is not the principal. Okay, so that's defense as to effect. Now there's another defense as to source naman. First, as to source, first defense is legal. So the legal defense are those provided for by statutes or by the Constitution. For example, prescription of crimes, marriage of the offender and offended, pardon, double jeopardy, amnesty. So these are legal defenses, no, that is provided for by the Constitution or by certain statutory laws. Next is the factual source, no, as a defense, which are those based on the circumstances of the commission of the crime relating to the time, the place, the manner of commission, identification of the accused, reasons for the commission, like for example, the alibi, self-defense, insanity, mistaken identity. No, so these are factual defenses, no, that are related to time, the place, and manner of commission, as well as the identification of the accused and the reason for commission. Okay, so those are defenses which can affect, no, criminal liability. Now, there are also circumstances that affects criminal liability, and these are called the modifying circumstances. And in the Philippines, the GEMA, no, are considered modifying circumstances. So ano ba yung GEMA? Ito yung justifying circumstances, exempting circumstances, mitigating circumstances, aggravating, and alternative circumstances. Okay? Now, what's the difference between these different circumstances? By the way, they are actually found, no, in the Revised Penal Code, which are special laws in jurisprudence. So the modifying circumstances are governed by the Revised Penal Code, includes these circumstances. So justifying, why are they called justifying? Because these are the defenses in which the accused is deemed to have acted in accordance with the law, and therefore the act is lawful. So since the act is lawful, it follows that there is no criminal liability and no civil liability. Okay? So what are the examples of these justifying circumstances? And this would be in the form of a self-defense, unlawful aggression, reasonable necessity of the action, or kaya there are means employed, no, to prevent it from happening, the lack of sufficient provocation on the person defending himself, uh, also defense of relatives up to the fourth degree of consanguinity, that in the case of provocation was given by the attack, that the one making defense had no part therein, uh, the defense of a stranger, uh, wherein defending not induced by resentment, revenge, or other evil motive. Or another example are those actions uh, that are done in fulfillment of a duty or in a lawful exercise of a right or office. No, like for example, yeah, it's a for soldiers, no, uh, for those who are yeah in the army. So yun. It also justifying circumstances also involves acts in obedience to an order by a superior or some lawful purpose. Okay, so yun. Because of these circumstances, justifying circumstances, the accused is freed from criminal and civil liability. No, if proven to be true and accepted. Next is the exempting circumstances, which are defenses where the accused committed a crime but is not criminally liable, and there is a crime, there is civil liability but no criminal liability. And the basis of this is the lack of any of the elements which makes the act or omission voluntary. So, um, yeah. So, because of this lacking element, no, no, that's why the accused is exempted. No, that's why it's called exempting circumstances. So there is a lack of element that makes the action voluntary. So there's no exercise of freedom of intelligence. It will be established that due care or intent was not present. No? So yun. Also, these exempting circumstances are defenses pertaining to the actor, no, and not the act. So they are personal to the accused in whom they are present, and the effects do not extend to the other participants. Thus, if a principal is acquitted, the other principals, accessories, and accomplices are still liable because these exempting circumstances are personal, no, or pertaining to the actor and not to the total act itself. So again, there is civil liability but no criminal liability. So, yun. Specific examples would be mistake of fact, no, and through ignorantia facti excusat, must be committed in good faith or under an honest belief. Also an insane or imbecile unless acted during lucid interval. Those acts committed by those under 9 years of age or over 9 under 15 unless acted with discernment. Also, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of doing it. Or those who acted under the compulsion of an irresistible force from a third person. Or those impulse of uncontrollable fear of an equal or greater injury. So, yeah. And also some lawful causes. Okay, so yun. These are exempting circumstances. Once established, frees the person from criminal liability, but still there will be civil liability. Next is the mitigating circumstances, are those which present results either to I'm sorry, mitigating circumstances are those which, when present, results either to the penalty being reduced by at least 1 degree, or the penalty shall be imposed in its minimum period. So, yun. So, in short, it decreases the moral culpability of the offender. Okay, so it decreases the malice. And specific examples would be because the person is under 18 or over 70 years old. There are also it will be established that there is no intention to commit so grave a wrong, as long as it will be it will be established. Also, it will be established that there was sufficient provocation or threat on the part of the offended party immediately preceding the act. Voluntary surrender could be a mitigating circumstance that decreases the moral culpability of the offender. Also, any illness that would diminish the exercise of his willpower, and those committed in the immediate vindication of a grave offense to the one committing the felony, like his or her spouse, ascendants or descendants, legitimate, natural or adopted brothers or sisters, relative by affinity within the same degree. No? So, yun, committed in the immediate vindication of a grave offense to the one committing the felony, and also acted upon an impulse so powerful as naturally to have produced such result. Okay, so yun, those are mitigating circumstances. Now, there are special mitigating circumstances, and these are called extenuating circumstances. And these are those which have the same effect as mitigating circumstances, but are not among those mentioned. No? So, they are provided for in certain articles of the Revised Penal Code and applied only to certain felonies. That's why they are called special mitigating circumstances. So maybe later on, no, if you want to further study these. So we have this such a thing, no, special mitigating circumstances. Example of these extenuating circumstances would be abandonment in case of adultery, release of the victim within 3 days with the purpose not attained, in the felony of slight illegal detention. So yun. Next is the aggravating circumstances, which are those which, when present, will result either to change in the nature of the offense as to make it more serious and result to the imposition of a higher penalty. The penalty being imposed in its maximum period, and they are provided for by the Revised Penal Code as well as by special laws. So what are these aggravating circumstances? Specific examples. This could be because of increasing the moral liability of this could be because of the advantage of public position. So, in contempt or insult to public authorities. Like you will be held in contempt of the court. Crime committed in the place of worship. These are aggravating circumstances. Abuse of confidence or obvious ungratefulness. Committed on occasion of epidemic, conflagration, shipwreck, or other calamity or misfortune. So, these circumstances aggravates the moral culpability. Also, in consideration of a price or reward or promise, They are also committed by means of fire, explosion, stranded of a vessel, and premeditation is very evident. It was carefully crafted. There was evident fraud and disguise. Okay, so these are aggravating circumstances. Next is the alternative circumstances, which are those which may either be appreciated as mitigating or aggravating. However, and they are enumerated, no, in the revised penal code if you want to further review them. So in general, justifying circumstances, exempting circumstances, no, are recognized as affirmative defenses, which are again uh, which are again a defense where the accused admits authorship of the act or omission charged and imputed to him, but he puts up matters to avoid criminal liability or which will result to his acquittal. Okay? So, ang dami, no? Yeah. Now, there are specific crimes which concerns nurses, and these are parricide, which is a crime committed by one who kills his or her father, or mother or child, whether legitimate or illegitimate, or any of his or her ascendants or descendants, or his or her spouse. So, yun, that is parricide. Murder, on the other hand, is the unlawful killing of a human being with the intent to kill. A homicide is the killing of a human being by another, while infanticide is the killing of a child less than 3 days of age. Abortion is the expulsion of the product of conception before the age of viability. And in our country, no, this is a crime, although in other countries, these are parang acceptable. Another crime that involves nurses would be giving assistance to suicide, wherein the nurse helps a person to take their own lives through any means available. Illegal detention, which is an unlawful taking of a person or property, as in the case of forcible entry, no, or detention. There are also crimes about simulation of birth, substitution of one child for another, or abandonment of a legitimate child. On criminal negligence, it could be by reckless imprudence or simple imprudence. When we say reckless imprudence, it is when a person does an act or fails to do it voluntarily but without malice, from which material damage results immediately. Okay, so yon. So there is no malice, no evil intent, but an act was done, no, or it could be an action was omitted. Um, Next is simple imprudence. It is when the person or nurse did not use precaution and the damage was immediate or the impending danger was not evident or manifest. Okay, so these are simple imprudence. So again, these are the crimes which usually concerns specific crimes which usually concerns nurses. All right. Now, there are areas where nurses have legal responsibilities as she uh, practice her profession, and this would be in areas where there are contracts involved, informed consent, in the wills of the patient, especially if there are advance directives. Um, Also, during the performance of nursing care, no, the nurse is legally responsible for the nursing care, operation of patients, particularly abortion cases. No, nurses have legal responsibilities in this area, and also during DAMA, no, during discharge against medical advice, or there are unauthorized discharge of patient. Yun. So, nurses must be very careful, no, in looking into their specific responsibilities in these areas. Now, how do we avoid criminal liability as nurses? There are a few points, no, that we can discuss, and we can observe, I mean, as nurses. First is we need to be very familiar with the Philippine nursing law. So I would, yeah, ask you to read the contents, no, of the Philippine nursing law. Beware of laws, no, that affect nursing practice, and these laws are listed, no, in the handouts that were given to you in Canvas. So kindly go over with those laws. I'm sure that you have encountered those specific laws also previously in the previous courses, no, that you have taken up. Also, at the start of employment, you have to get a copy of your job description, the agency's rules, as well as the regulations and policies, so that you will know how to conduct yourself, no, in the practice of your work in that particular company or agency. Also, make sure that you upgrade your skills and your competence as you go on, no, in this profession. Another suggestion is to accept only such responsibility that is within the scope of your employment and job description. So feel free to refuse, no, those that are beyond what you were trained for. Also, do not delegate your responsibility to others. Um, Make sure, no, that you are not doing this recklessly. Do not delegate your responsibility to others. By the way, these are the materials that we use, no, in this learning session. And thank you. Thank you for listening. So again, I ask you to read through the handouts, no, that were shared with you at Canvas. Thank you, everyone.